Hello. In this week's Torah portion, Vayikra, we learn that the witness is obligated to testify. Quote, if someone sins because he did not testify, after being required to testify regarding what he has seen or learned, he will be held responsible. Unquote. However, the Talmud states that there is no punishment for failure to testify, except from God. Quote, Rabbi Yehoshua said, these are acts for which the offender is exempt from the judgments of man, but liable to the judgments of heaven. Hiring false witnesses to give evidence, and knowing evidence in favor of another, and not testifying on his behalf. Unquote. Our question today is, if you're a witness, can you be compelled to testify? First, why wouldn't you testify? Many possible reasons come to mind. You may not want to get involved. You may not want to take the time to do it. Perhaps doing it would entail loss of income, as you would have to take time off from your work. You may not want to have to endure a cross-examination, which may entail having your own past probed and your private life dragged into the open. You may be afraid of the consequences of testifying. You may have received threats of harm to you or your loved ones. You may fear ostracism from your community. You may fear loss of your livelihood, and so on. Finally, you may be prosecuted yourself as a result of your testimony. A promise of immunity from prosecution may not be enough to overcome your reluctance. Here's a relevant story from the Talmud. Quote, a man went to Mari ben Isaac, claiming to be his brother, and said to him, give me a share in the property of our father. Mari answered him, I don't know you. The claimant then came to Rabbi Hisda, who said to him, Mari answered you well, for it is written in the Torah, quote, and Joseph recognized his brothers, but they did not recognize him, unquote. So it is possible for brothers not to recognize each other. Then Rabbi Hisda said to the claimant, go and bring witnesses that you are his brother. He answered him, I have witnesses, but they're afraid of Mari because he's a powerful man. Rabbi Hisda then said to Mari, go and you bring witnesses that the claimant is not your brother. Mari answered him, is this really the law? Surely it is the claimant who must produce evidence. Rabbi Hisda said to Mari, this is my ruling for you and for all those who are as powerful as you. I apply the rules according to circumstances. But it was argued these witnesses may lie. The rabbi replied, they will not commit two wrongs. They may refuse to testify because they're afraid, which is wrong, but they will not also lie, unquote. So it is the intimidating party who must bring the witnesses to argue his side. One wonders how far that ruling goes. At any rate, the implication here is that witnesses may not be compelled to testify. Let us review what the Torah says about witnesses. First, at least two witnesses are required. One witness alone cannot lead to a conviction. The Torah states, quote, one witness shall not rise up against a man for any iniquity. By the mouth of at least two witnesses shall the matter be established, unquote. The Talmud even reports a case of a witness who was punished for testifying because he was the only witness. Quote, it once happened that Tuvia sinned, and Zigud alone came and testified against him before Rav Papa. Whereupon Rav Papa had Zigud punished. Zigud exclaimed, Tuvia sins, and Zigud is punished? Rav Papa said to him, it is written in the Torah, one witness shall not rise up against a man. When you testified against him alone, all you did was bring him into disrepute, unquote. Second, if the defendant is convicted and sentenced to death, the witness must be the one to begin the execution. The Torah says, quote, the witness's hand shall be first upon him to put him to death, and afterwards the hand of all the people, unquote. Third, there's a commandment against giving false testimony. It is even one of the 10 commandments. The false witness even incurs the penalty that would have been inflicted upon the accused had he been convicted. Now, let us learn what Jewish law added about witnesses through the Talmud and subsequent commentary. First, the witness must have seen the event himself, or heard from a party to the event. He may not testify to things he does not personally know, or to what he has heard others say. He is allowed, however, to look at notes he wrote at the time. Second, in criminal cases, the witness must testify of his own accord. However, in civil cases, he is obligated only when he is summoned by the court. Third, a spy planted to hear or see wrongdoing is not a valid witness, except in cases of incitement to idolatry. Fourth, the following may not testify in a Jewish court: women, slaves, non-Jews, minors, the mentally deficient, the deaf, the mute, the blind, the wicked, the contemptible, relatives of the defendants, and interested parties. Let us review these exemptions. Women are exempt because the rabbis do not want to take their time away from their duties at home, which they deem more important. However, women can testify if there are no male witnesses. In Israel, since 1951, women can testify. Slaves and non-Jews are exempt because witnesses must be free Jewish citizens. However, non-Jews may testify if secular laws require it. Minors under 13 are exempt, and even young men between the ages of 13 and 20 can testify only if they prove to have understanding and experience. The mentally deficient are exempt because they may not understand what's going on. The mute are exempt because witnesses must testify by speaking. The deaf are exempt because witnesses must hear the instructions and warnings of the court. The blind are exempt because the Torah says what he has seen, and the blind cannot see. The wicked are exempt because the Torah says, quote, "Do not put your hands with the wicked to be an unrighteous witness," unquote. The fear is that the wicked are more likely to lie. The wicked include broadly criminals, swindlers, perjurers, illiterates, and informers. Specifically, they include thieves, usurers, tricksters, gamblers, gamesters, idlers, vagabonds, tax collectors who receive a portion of the money they collect. They include those who are ignorant of Bible or Mishnah and of standards of conduct, unless their conduct is irreproachable. They include the contemptible, that is, those who do not conform to social conventions, such as by walking around naked while working. They also include agnostics, heretics, and Torah transgressors, whether through conviction or malice. In sum, only observant Jews of good character are allowed to testify. A broad range of relatives of the defendant is exempt from testifying: father, uncles, brothers, sons, nephews, stepfather, father-in-law, brothers-in-law, sons-in-law, and first cousins. If the relative is a woman, her husband may not testify. Further, witnesses must not be related to one another or related to one of the judges. The defendant may not testify for or against himself. Finally, interested parties may not testify. A witness cannot testify if he gets any benefit from his testimony. In addition, if a witness is paid for testifying, his testimony is invalid. Witnesses can be cross-examined. If two sets of witnesses contradict each other, both sets are ignored. In American civil law, the court can force you to testify by subpoena and put you in jail for contempt of court if you refuse. Exceptions are allowed when you would incriminate yourself, you are the defendant, you are not competent, or you are the spouse, attorney, therapist, or clergyman of someone involved. So, the two systems have more similarities than differences. Shabbat Shalom.